that are participating via the web that you are very welcome and, in fact, eagerly invited to submit questions via email. You should see an email address for doing that right in the live webcast page. So please send us your questions. We're very interested in your thoughts or comments. Our speakers can also respond to comments. So we're very lucky to have Paul McCulloch here, who's counsel with the Ontario Ministry of Environment and a well-known expert in the field. And he's going to be talking about strategic decisions in environmental prosecutions.
Thanks, Linda. Well, I don't know about expert. I do have a number of years now with the Ontario Ministry of Environment Legal Services Branch. I will point out that the views I'm expressing today are just my own observations. They're obviously not attributable to the province, either the Ministries of Attorney General or Ministry of Environment. And what I'm presenting on, I was asked to present on strategic, I think that the title was Strategizing Environmental Prosecutions, and we could do a whole course on that. So I've just chosen what are some of the more common issues that arise in a prosecution. I've renamed it a bit and called it strategic decisions that are made throughout the course of a prosecution. And it's not an exhaustive list. It's as I say, just the more common things that arise. There is some overlap between Alex's presentation this morning, so I'm going to try and focus on the areas where there aren't overlap. I think I'm going to try and be a little more on the practical side. I think Alex gave a great theoretical background, and also at the initial stage as to what the Crown has to decide whether to proceed. That duty does pervade throughout a prosecution. Obviously, as new information comes to light, you always have to reevaluate whether you should continue a prosecution. But once the decision to proceed has been made, then a number of other tactical and strategic decisions arise, and I'm going to try and address those. And there's nothing too novel or exciting in the structure. I'm going to start at the beginning and go to the end. It doesn't get much easier than that. One quick slide on regulatory, what regulatory prosecutions are, and then I'm going to start with the inspection and investigation stage, because a number of important decisions, especially for defendants. I mean, I'm a prosecutor, but I am going to try and make some comments on observations I've made about decisions that defense counsel have to make, and hopefully that'll be of use to some of the participants today. And then move just right through all the way in to sentencing. So we've already had mentioned that most environmental prosecutions are regulatory prosecutions. I'm not going to give a great deal of background. I'm not going to go into the two seminal cases, Sault Ste. Marie and Wholesale Travel. I just wanted to focus on what the purposes of environmental prosecutions are. It's to protect a public or societal interest, prevent future harm through the enforcement of minimum standards of conduct and care. And that's when you set standards in various regulations or various permits and approvals, you're trying to set minimum standards, and it is always a minimum standard. Most approvals and licenses in Ontario often have a general clause that says just because you're complying with this permit doesn't necessarily mean you can't be prosecuted under our general prohibition for causing some sort of an adverse effect. So they really are meant to be minimum standards at times. And these are not like criminal code offenses where there's a moral element to them. But in terms of making strategic decisions for the Crown, the most obvious strategic decision is for regulatory regime, and I should have had the word strict liability on the slide. It's known as a strict liability regime. The Crown does not have to prove a mental element. And so when it comes to deciding whether to proceed and what evidence to lead, obviously that is the pervasive factor. Crown only has to prove the actus reus, taking, as Linda said, taking you back to law school, remembering all your Latin terms, the actual elements of the act of the offense. And not required to prove a mental element, but the defendant can prove due diligence or reasonable care is the more broad term on a balance of probabilities. And this has been upheld by the Supreme Court as constitutional in the decision of wholesale travel in 1991. Now, I've indicated you don't have to prove the mental element, but Alex alluded to this, and I think it's a good point. A strategic decision for the Crown is whether you still want to lead some evidence of mental element. And there are still good reasons to do that. Number one is it's much easier for a justice, I think, to convict somebody when they feel like there's been more than just a mistake made. If you have evidence of some sort of intentional or recklessness or gross negligence, you're going to want to probably lead that evidence in any event. So that's one of the first strategic decisions the Crown has as to what your theory of the case is, how you're going to present your case. And it also leads into, first, do you proceed? If it's really, truly just a mistake, do you even proceed? But once you decide to proceed, how you shape and frame your case. And then the second reason is sentencing. The mental element does come back on sentencing. So that's another reason you have to make a strategic decision. Are you going to lead the evidence in chief, or are you going to wait and, if you get a conviction, have a separate evidentiary stage to the trial at the sentencing hearing? There can be reasons to do that. You might decide that some of the evidence might be prejudicial. You might not want to color your case too much up front, but most of the time it's going to work to your advantage to have it in chief. You're going to be helping your case. So I indicated I'm going to go back right to the inspection stage. And the reason for that is because, especially for defense counsel and for the solicitors of the world out there, this is the big moment for solicitors to shine. What you do with your clients before they ever get approached by an enforcement agency is really one of the most strategic decisions you can make. We would rather be out of business as government regulators. We would rather have everybody getting great legal advice and complying with the statutes, and we would all like to have other jobs. That's not going to happen, but for the defendants out there who get legal advice on how to comply, you're going to be one step ahead of the process, that you're not going to get into the whole prosecution's issue at all. So I wanted to point out, and there is ability to do that because in Ontario at least, and I believe other enforcement agencies are similar, many of our inspections are done, are what I call planned inspections. We know who we're going to inspect mostly at the beginning of any fiscal year, and more importantly, we contact the facility ahead of time and tell them we're coming. And the reason for that is because a lot of what we review isn't the facility in action. We're not testing. We do take samples and we do some of that, but a lot of the time we're reviewing data that has to be kept. And I'm going to speak a bit more about that on a later slide. So we want to make sure the person's there and the data's there, or not the person, but there is a person at the facility who can answer questions, can walk the inspector through a lot of the necessary information. And so we do give notice and we show up. So a defense counsel making sure that if you're going to get inspected and you've got the data there, make sure it's available and make sure that you've reviewed it in advance and you know what your requirements are. The self-reporting mechanisms, in fact, some of our self-reporting mechanisms now don't even require an inspector to go to the site. For our drinking water compliance in Ontario, all of the lab results are automatically loaded by the laboratory, not by the drinking water facility, which are mostly municipal corporations, but some private. As soon as they submit their samples to the lab uploads them to a database that is automatically accessible by our inspectors, And I believe there's even a program that if one is missed, because we know how many are supposed to be taken every month, so forth, there's automatically an email sent to one of our systems, and we know immediately that they've missed. So we're relying more and more on this type of self-reporting, and the need to have the upfront advice from Defense Counsel for people for the regulated community is an important step in terms of a strategic decision that should be made by defendants or the regulated community. Hopefully they won't become defendants in that case. The other, so that takes care of the first two. The others, random inspections, complaints, referrals from other agencies, and whistleblowers are a much smaller percentage of the actual source of why we are dealing with a regulated entity, but those four often result in a lot more work. And especially the complaints, if the complaints come from the public, obviously we need to respond, and we need to let whoever some complainants want to remain anonymous, so it can get more complicated, but sometimes another strategic decision that a regulated community can make is to try and deal with the complaint head on. And nothing is going to make the enforcement agency more happy to know that a regulated entity dealt with the complaint and dealt with it to the satisfaction so that we don't have to do anything. Obviously, that's another decision that a regulated entity can make. Try and deal with these complaints, and don't make the enforcement agency come in and become the mediator, because that's just going to make your life more difficult. And then, you know, the random inspections, we do some random inspections, so I don't want to make it sound like the ministry never goes out. We do, and when we get a complaint, we will often show up unannounced. Our drinking water inspections, for example, are 1 in every 3, I believe, are random. That was a specific recommendation that came out of the Walkerton inquiry, so we do show up unannounced. And again, having staff that know what to do in those situations, because as we're going to see later on, there are our inspection powers are backed up by powers, offenses for obstruction, providing misleading information. So having people who know what to do when the enforcement agency shows up is also another sort of strategic decision that should be made up front. So hopefully you don't even get to that stage where we're contemplating some sort of enforcement action. But if there is a problem after an inspection and an enforcement officer says, you know, you've got these problems, this is another opportunity to not get to the prosecution stage. You know, what can you do to stop it from being referred for an investigation? And there are many opportunities. First of all, you know, how fast can you get your facility into compliance is going to be a big part of assuming it's not a major incident. And the ministry does have a specific written compliance policy that indicates to guide inspectors to determine, you know, I've looked at the number of different responses here. So we do consider voluntary compliance in certain situations, and that is one of the factors. How fast can they come into compliance? What sort of assurances is the ministry going to be given? And it's generally for the less serious type of offenses, the more of the paperwork type offenses or training. You know, if somebody doesn't have the right training, but I will get them registered in this course by the end of this month, and they will go, you know, and I will provide you with a certificate by this date. Well, and you know, the inspector follows up, and sure enough, they get. That's great. That's the sort of thing that is appropriate for voluntary compliance. Otherwise, the ministry sometimes will issue orders. Again, there's a chance. I see orders sometimes almost like a contract. You sit down and you say with the regulated community, here's what we need to accomplish. How can you do it? And the regulated entity will say, we can do this, this, and this by these dates. Okay, let's put it into an order. You accomplish those. And again, it's another alternative prosecution. So again, it's a strategic decision for the regulated community up front to try and deal with these matters without getting into the prosecution stage. There are environmental penalties in Ontario. These are administrative penalties. They're only for a small sector of the regulated community. I'm not going to spend a great deal of time on them. We don't use them as widely as, say, I think securities, the securities regulation. Alex was, or no, it was another Alex was indicating earlier that the aeronautics uses them, I believe. So we don't use them nearly to that extent. I'm not going to spend a great deal of time on that. We do have tickets, again, just for generally lesser violations. The maximum amount of a ticket is $1,000, for example. So we tend to use them for more also for individuals than corporations, individuals who don't have their well driller's license or that sort of thing, or haven't submitted their records on time, that sort of thing. It's when all that fails, so you can see what the whole lead up to, or it's a very serious incident from the beginning. And so under those two situations where, or I guess a third situation might be where there's a repeat offender. In those three cases tend to lead, we might go straight to an investigation stage. Now, I did have a slide on inspection versus investigation. I think Alex dealt with this. I've even got the same cases up here, Jarvis and Nolay. And I believe the third case I've referred to at the bottom, Larson, might actually be the same case, Western Mining, was it? Or Western something. Anyways, I believe it's the same case, just under a different name. So I'm not going to spend much time on the inspection versus investigation. I just wanted to point out that most inspection officers have broad powers for warrantless searches. Not searches, sorry, warrantless inspections. And the self-reporting requirements that I've spoke about earlier, and in addition to data, you have to keep training records, you have to keep volumes of things coming in and out. There's just numerous records that are required by either our regulations or by our individual permits and approvals. And that has also been upheld by the Supreme Court of Canada in a case called Fitzpatrick. It was a case involving fisheries, where it was similar to the case that Alex described that he had that a fisheries officer went onto a fishing ship and asked to see the logs, and the logs clearly indicated that the fisher had caught way more fish than they were above their quota. And the evidence that was used was the logs, and the Supreme Court upheld that as being a valid, as long as the requirement to keep the data is consistent with the purposes of the regulatory regime, then that is not violating any right to self-incrimination or is not an unreasonable search. So another strategic decision for defendants is to make sure you've got all the right records, because if you don't, we're going to charge you with not keeping the right records, and that's going to just lead to it's going to end up in just a bad situation as whether you've got records. It's like the difference, I guess, to put it in a criminal context, the difference between blowing over and drinking and driving and not refusing to provide refusing to provide a breath analyzer test. It's both got pretty serious consequences. Okay. So one difference in Ontario in our Ministry of the Environment, and it is helpful for the whole investigation versus inspection issue, is that the ministry has separate branches. We have a separate investigation branch from our inspectors. And this is useful for demonstrating that the ministry hasn't crossed the Rubicon, as the Supreme Court case describes it. What's also useful is if there is an ongoing situation, our inspectors, which we call abatement officers, will continue to follow up with the regulated entity to ensure they come into compliance, whereas the investigator will start a separate sort of investigation. And it's important for the regulated community to understand the difference between the two, because you definitely want to cooperate with the abatement officer, but there are strategic decisions about whether to cooperate with the investigator or not. And this isn't true of all, by the way, just of all Ontario. It's only true of the Ministry of Environment. Other enforcement agencies, such as the Ministry of Labour, have the single inspector model where the inspector has to, as you say, wear two hats and decide at what point it's going to become an investigation, at what point it's going to be stick with the compliance side of things. Once it has been referred to investigation, the investigator will make it clear that he or she is an investigator and here for purposes, and that's now another very important, I think probably one of the key strategic decisions for defendants is what degree do you cooperate with our investigators? There are numerous documents and various information and then statements that the investigator will request. And the initial reaction for many defense counsel is probably, well, why would you ever voluntarily provide anything? And there are defense counsel out there. In fact, we know certain facilities that we don't even bother. Well, we always ask, but we know what the answer is going to be, obviously, because that's just the strategy of the defense counsel who represents those facilities. But let me give you some reasons why it is sometimes in the interest to cooperate with the investigator and provide information. First, if it's a chance to provide evidence of a due diligence defense up front. And there have been times where even the investigator has, usually the investigators will seek legal advice on due diligence defenses, but sometimes some of them have been around long enough, they know when they see a due diligence defense, a real, honest, good, true due diligence defense, and they won't even recommend the charges proceed. A second reason is there may be a multiplicity of actors involved, and I'm going to get to that in a minute. So there's subcontracting arrangements and landlord-tenant arrangements, and you may wish to point out somebody else had a much greater role or is much more culpable than your client. But probably one of the main reasons is to avoid search warrants, because that will be one of the recourses the investigator will choose if somebody doesn't voluntarily provide information. They're going to think about getting a search warrant. They're going to come in. Search warrants can be very disruptive. They can involve taking hard drives out of computers and replace. We do try to copy them and provide people with replacements. We're not leaving them without any data, but we're going to, it's not an easy process. It'll take a day or maybe more if it's a large facility where your whole operation is going to be put under a fair bit of stress. It also avoids, by providing information voluntarily, the investigator contacting employees at home, contacting maybe suppliers, or contacting your customers to get certain information. And many defendants may wish to avoid that whole scenario. And then there's just the whole court of public opinion, of course. Cooperated fully is something that people often want to portray out there. And it also can be an issue on sentencing as well. The obvious con is that you're providing evidence that can be used against you in a defense. So that's, in a prosecution. So that's a key decision. I have never had to make the decision. I've seen defense counsel weigh it, but that's a key strategic decision that defense counsel has to make. In Ontario, there is so it's a two-step process. The investigator makes the initial decision as to whether he or she thinks there's enough evidence to proceed. It is then put into a Crown brief, and that's given to legal counsel for an opinion, a second opinion as to whether the charges should proceed and exactly what charges should proceed. That's all done electronically, by the way, in Ontario, just out of interest, and we now provide disclosure on a CD-ROM. So what used to be binders and binders of materials has become somewhat better, and it has searching capabilities and things like that. So that's an interesting step. And Alex indicated what the rationale and the reasoning is as to whether to proceed or not. So I'm going to move on to what charge. And now we're getting more into the strategic decisions that the Crown has to make. And there's our more common offenses, some of the, mostly they're, I don't like this word, I use it sometimes in court, a paperwork offense where you just don't have the right information. I don't like it, and there's some good case law, and I always back it up with this case law, because the paperwork, by complying with the paperwork, is how you prevent offenses from occurring in the first place. And I think the case law, the one case describes it as a violation or a contravention of the environmental protection process. That's probably a better word than a paperwork offense. Some of the paperwork's pretty important. And so we will prosecute where it's sort of a gross, not taking records of certain things. If we don't have the records, there's no way we can determine whether you're actually in compliance. So if you're just failing to take records at all, that would, of records of important processes, so that we can determine whether you're emitting within your limits, for example. If you're not keeping those sorts of records, that would be a much more serious than. Sometimes you have to keep logs, and people have to initial whether they're the person that was in that day. If you're just missing a few initials, that might not be so serious. But again, if something goes wrong on that day, just to provide a counter argument, knowing who was there and who did what by who put the initials on the log can often be a key piece of evidence. So even something as small as that, we take fairly seriously. But I think the biggest decision for the Crown is whether you have the evidence to go for one of the more serious offenses, and whether to go for isn't really the right word. Does the public interest justify proceeding with one of our more serious offenses, which are typically the discharge type offenses? Something is being discharged, and in Ontario the term is adverse effect. It's causing an adverse effect. If there's actual evidence of an adverse effect or likely to cause an adverse effect, those are one of our more serious charges. Failing to report any of the spills and upsets and accidents, again, another one of the more serious offenses. I mentioned earlier obstruction and false and misleading information. Any type of offense that involves toxic and hazardous substances, and things like where there's actual habitat destruction. And there's a number of factors that go into whether, what's the charge going to be? And there can be multiple charges, obviously. We've had informations with, 10, 20 counts on them. Sometimes you'll do a mix, and if there's enough evidence and the time period, how long the offense goes on for. So who to charge? This is one of the slides I was going to spend a fair bit of time on, because this is, I think, for the Crown, another strategic decision, and one for defendants as well. The simple case where one person discharges something and causes an adverse effect is not always the most common situation. I'm finding more and more that there are a lot of, especially because of contracting and subcontracting, there's so much of that goes on in the construction industry, in various other, even for a facility, they often contract the environmental personnel to come in from some sort of specialized consulting firm that does the sampling and testing for them and compiles the data for them. You can hire people to do that. So when something goes wrong, it's not always clear who immediately is the perpetrator. And we end up sometimes prosecuting everybody, but we're always trying to look for who are the most culpable. Again, this is where intent does come back into it. And we can charge as the principals, or as also the party to an offense principles. Party to an offense, I shouldn't use the word principle, party to an offense doctrine, where even though somebody isn't the primary, the classic example is we issue a permit to a person, and then somebody else does something that causes someone to go out of compliance with the permit. And because they're not named in the permit, their argument sometimes is, well, you can't prosecute us, we're not named in the permit. And we've used the party to an offense doctrine to bring people in those cases. And then corporate officers and directors. Of course, when it comes to environmental law, numerous defendants are corporations. So you can use the party to an offense doctrine to bring in corporate officers and directors, and the case I've quoted there actually wasn't in the paper that I provided, so I've put the full cite, a case called Fell, especially when it's a small 1 or 2 person corporation. We tend much more to go and name the officer or director in a charge because the degree of separation between the corporation and the individual is much less, is much closer in proximity. Large corporations where there is more of a true separation between the board of directors and the operational aspects, we need to generally have some sort of evidence that the corporate officers didn't oversee things properly. We do look at managers, and in those cases, individuals who are the ones that were making the on the ground decisions as well. And the deterrent effect of prosecuting individuals is much higher than just having the corporation. And of course, the range of penalties. Most importantly, the effect of a probation order or a possible jail term. And people have gone to jail under environmental laws, certainly in Ontario. The deterrent effect of that is much greater than simply imposing a fine on a corporation. Employees and agents, there have been, we've also prosecuted employees and agents. There's a seminal case from New Brunswick where a consulting firm was prosecuted because they gave terrible advice, I believe, to a municipality as to how to comply with a case. They had a landfill or something that was leaking into a river, and they proposed a solution that just allowed the municipality to continue leaking. But something I didn't have on this slide, and which I think I do want to add, is another defendant that we often see are municipalities. I'd say as much as 10 to 15% of my cases are municipal defendants. Sewage treatment plants, landfills, I mentioned drinking water, their public works departments, and some of the municipalities are some of the biggest corporate entities in some of the provinces. I think of City of Toronto. Here in Ottawa, we have the City of Ottawa, which is an amalgamated city. It's very large. Its budget is something like $2 billion, and we have had cases against the City of Ottawa. A rather famous case, which I was going to make all sorts of defaming comments about, but defense counsel for the City of Ottawa has shown up today, so I'm going to have to keep my comments tempered. But it got a lot of media. And it was a case involving a large sewage spill into the Ottawa River, and that I think is the exception. Actually, most of the municipalities, it's more the smaller, trying to keep track of all their employees. They have a large number of employees. They're again the whole balancing between they're trying to deliver a number of services, and I think they just unfortunately don't always exercise due diligence. And again, who to charge? The province certainly won't hesitate to charge municipalities where they haven't complied. And there is case law, by the way. I don't have the cases at my fingertips, but that make it clear that municipalities shouldn't really, certainly not at the prosecution stage, be treated any differently than private actors. When it comes to sentencing, there's case law both ways as to whether the municipalities should be treated any differently. But we view that the deterrent effect of a fine is useful for prosecuting a municipality. And the City of Ottawa case, by the way, I think is a good example. I really like what the City of Ottawa did in that case. They forced the Public Works Department, the fine was $450,000, which is a fair amount. They forced the Public Works Department to figure out of their smaller budget, how are they going to come up with that savings? So it put the responsibility on the agents who caused the problem, which I thought was a neat outcome. They also did, by the way, fire 3 employees. So I talked about earlier about prosecuting individuals, but where the defendant takes it upon themselves to take matters into their own hand with individuals, that's another factor that comes into play. I've just dropped my watch, so I'm just going to see. I've got about 5 minutes. Okay, Okay. I will move on then. Plea discussions is just a key time. I'm not going to get into it in any great detail. A lot of the issues I've discussed come to a fore during plea discussions, and where that often comes to a real crux is at a pretrial. And my one comment for if there's any judges or justices watching is that it's very helpful when justices take an active role in a pretrial and give their thoughts based on the limited evidence that's often presented as to what they think a case might, which way it might go. And even if a resolution can't be reached at a pretrial, I always try and narrow the facts, come to an agreed statement of facts, just to try and shorten a trial as much as possible. For trials, I'm just going to, there's a myriad of tactical decisions that have to be made in any trial, and I'm not going to get into, they're the same for many criminal cases or quasi-criminal cases, but there's one unique thing in Ontario, and that's whether to proceed before a justice of the peace or a judge. And I believe in most provinces it's just straight to a judge. But in Ontario, most of the regulatory offenses are heard by justices of the peace. And the Crown can elect to choose a judge, but I'll tell you, I rarely do that. Mostly because some of the issues, some of the expert type evidence issues that arise and some of the sort of facts, I don't know if judges have any more background than justices of the peace on those types of things. In fact, we had a really interesting case. Alex spoke about expert witnesses, so I'm not going to say any more, but I had an interesting decision come out from a justice of the peace where we led experts about sampling, and we had, I think, 3 or 4 days of expert evidence, 2 on the defendant's side, 1 on the Crown side. And in the decision, the justice said, I really didn't find any of it all that helpful. I found that I could figure things out myself. It was kind of more common sense. I didn't really need the experts to know whether somebody who has chain of custody of a sample and whether they take it to the lab and whether the lab technician uses the right quality control measures. Those are all sort of common sense. And it was sort of a case where maybe we kind of wasted a lot of court time. So it is another strategic decision. Do you use experts or not? You really have to think. I liked Alex's comments about, sometimes maybe it's better to step back and stick to the big picture than try and overwhelm a court with all sorts of expert evidence. In terms of evidence, there are just two specific rules that kind of arise in environmental cases a fair bit. One, there are a lot of documents. I mentioned there's approvals and licenses and things, and there's not just the approval or the license, but there's also all the supporting documentation that goes with it. And I had a recent case where that was the issue, where they were required to do some sampling on a regular basis, and they did the sample, but there was a supporting document to their approval that said how they were going to do the sampling. And our interpretation was that the sample had to be what's quote unquote representative of a load of waste. And their interpretation was, no, we just have to do these 6 samples, and if we do that every time, we're fine. And there was a unique situation where our allegation was that there was waste hidden below. So by just sampling on the top, they weren't getting a representative sample, and we said you didn't sample properly. And their argument was, we did the 6 samples like we said. And we were successful at trial, and that's actually under appeal right now. So we have these statutory rules that allow all of this documentation to be put in if they've been submitted to the ministry, and those are very helpful, and they can get a lot of documentation in. And I often try and work out with Defense Counsel. We'll often show up with a binder of documents with tabs already, and to put them all in one by one and prove them one by one just takes so much time. So we do have this useful statutory rule to allow these documents to go in, and usually Defense Counsel won't object. And then there are hearsay exceptions. The one I want to focus on most are statements by employees in particular. It could be any type of a statement from a defendant, correspondence. I indicated the self-reporting requirements. Those often come in on a letter. We get a letter attaching a lab result. We exceeded our limit for this month. Well, to get all that evidence in would take an enormous amount of time under the traditional rules of evidence. but to use the rule that you can put admissions by a company in as a right makes it much easier for the Crown. So that's a strategic decision the Crown often has to make. What evidence am I going to call, and how am I going to call it? And again, defense counsel have to decide, are we going to try and object or not? There are two presentations on defenses, so I'm not going to speak about defenses. I just want to speak about the one defense that can't be made, which is a collateral attack. I've already indicated there's a number of permits and licenses that are issued, and sometimes the ministry will issue an order. Most of those documents, when they're issued, those instruments have an appeal right. You can appeal them to, in Ontario, it's the Environmental Review Tribunal. I know British Columbia and Alberta have similar type bodies. If you don't appeal them, and you're later found to be in contravention of a requirement in those instruments, it's very difficult to argue, once you're prosecuted, that there was something unfair or that the ministry didn't have jurisdiction to impose those. So you have to, the strategic decision, again, for defendants is whether to appeal it in the first place. And that's an important decision, because once you pass up on that opportunity, you're stuck with the requirements. And that was a case called Consolidated Mabrun Mines. That's a Supreme Court case, exactly that, where the ministry issued an order to a mine. And the mine ignored it, and then years down the road tried to argue that the order was improper and was told could not do that. And so the prosecution was successful. How am I for time? Right at the end? Okay, because this is my last slide, so I just want to know how much to spend. Again, I think I didn't know that there's going to be another whole seminar on sentencing as well. So I won't say too much about sentencing. The strategic decision, again, is about how much you put in about intent into your case, really, because this is really where, although there's no mental element for getting a conviction, when it comes time to sentencing, the mental element as to, and in Ontario, we've put aggravating factors right in our legislation, that if it's intentional or reckless, that's an aggravating factor. And monetary gain, was the defendant warned? These are all things that are sort of the mental element, and those can result in increased penalties. Ontario doesn't have the specific creative sentencing provisions that the federal legislation now has. We do still try, for example, in the federal legislation, money can be put into trust funds, or money can be paid to various agencies to do work, or donated to a local group of some sort who's going to, Alex mentioned, do riparian rights work on a river, maybe some sort of watershed. But we do have court order powers, and we do sometimes issue probation orders to corporations. And we have had interesting terms and conditions in probation orders, and we do try and get creative as much as we can within the limitations of a probation order. And we do have, finally, minimum fine provisions. So certain offenses, if you're convicted, it starts at a certain amount, $25,000 for a first conviction for a corporation, for example, and it moves up after. So again, a strategic decision is, do you proceed with a charge on those, or do you agree to some sort of lesser offense? And there's Crown policies about when you can do that, when it's appropriate. And I think that's my time, so I'll take any questions now at this time.
Thanks very much, Paul. We do have some questions. So how significant in practice is the cost of prosecution as a constraining factor in the decision to prosecute?
The cost, it's not explicit. I mean, we are, we're government employees. We're salaried. We don't do a cost-benefit analysis explicitly. If it's a minor offense, I think, and you need expert evidence, I guess I can't say I've had that situation myself. I should add that we have in addition to our two-step process, we even have a two-step process within our legal services branch, whereas we have one Crown review all cases to try and determine if there's should go forward. I could ask that person. I don't think cost is a big issue. It's more the seriousness of the offense. If it's a serious offense, we will probably still proceed despite the cost. It's more, if only for the minor offenses would that probably be a big factor.
This question is somewhat related to a question that I had, and I don't know if you can answer this, but I'm curious whether the prospect of liability affects conduct at any stage. Do you think that an inspection or enforcement or any of those stages that people are thinking liability is a possibility if we don't act?
We have a separate, solicitor's side that does provide that sort of advice. I have heard of inspectors asking that, but because we do have going back to your presentation, actually, we do have an explicit policy called the compliance policy, and all of our officers are given training. There's a 3-week course for every officer that becomes a provincial officer on the general rules and legislation, and then the compliance policy. There's ongoing training. So I would have to say it's not a day-to-day factor. I think the officers rely on their training, and we rely on that training to insulate us. I will add there's a flip side to that, is that we do also get sued for malicious prosecution, right? There's sued from the victim side, but then we also have been sued for malicious prosecution. We do have one going on now, so we get it from both sides.
Okay. What strategic decisions are involved when a defendant is willing to make a financial contribution, e.g. to a charity, government program, or environmental fund in lieu of prosecution?
Okay, so in Ontario, the Attorney General has made the decision that there will not be any charitable contributions in lieu of fines. That's a policy, it's explicit, and as prosecutors, we're bound by that. That's a distinct difference from the federal legislation, which specifically authorizes that type of thing. We did used to do it, but in the 90s, you will still see summaries in some of the textbooks that say, somebody paid a donation, but we're not permitted to do that anymore. Some defendants will just do it up front, I think, to make an argument of remorse in front of the sentencing judge, and I have no control over that. And so that is still a strategy that a defendant might consider. But as part of a plea discussion, I'm not able to consider that any longer.
Okay, interesting. Last question. Second last question. Given the rights to silence in the Charter, under what circumstances does the MOE successfully charge for obstruction?
There's a couple of different types of obstruction. There's sort of physical obstruction happens. We have had officers who have been physically assaulted, and sometimes they have actually referred it to the police for assault, but they've been prevented from accessing a property. People have driven their cars in and boxed in officers with their vehicles, that sort of thing. The right to silence is only, it doesn't apply to records that have to be kept. That's the Fitzpatrick case from the Supreme Court. If it's consistent with the regulatory regime and you have to keep these records, and somebody willfully, I'm thinking now, Conrad Black taking his 12 bankers boxes away. If somebody does something like that, they have records and they specifically go in and shred them, and perhaps we get a whistleblower who says, I saw so-and-so shredded, well, then that would be another obstruction situation as well.
Okay, I'm not entirely sure if I'm reading this writing correctly, so please correct me if I'm getting this wrong. Are you concerned with recanting statements if information is voluntarily provided during the investigation stage?
Yes. We audio tape, our investigators audio tape all statements now. So we have an audio. If we have any concerns, there's another 2 answers. So 1, we audio tape everything. 2, we will send 2 investigators if we think it's somebody that we have some thoughts up front. And number 3, for defendants who we think might eventually be charged, we will caution them in advance. And again, there's always 2 investigators. It's always taped. We haven't moved to videotaping. I know some of our investigators have explored the idea of moving to videotaping so that if we have to use the statement, we can do so. And of course, we'll get a full transcript of the audio if we need it, if we think we're going to need it. I haven't personally ran into a recanting witness yet, but yeah, it can be an issue, especially where it's an employee who maybe at one point is jaded and then suddenly, gets hired back or something like that. These things do happen, so yeah.
Okay, this is the real last question that was buried in my pile. Has there been any litigation in Ontario accepting the institutional separation of inspectors and investigators as satisfying a bright line for purposes of Section 8 arguments regarding admissibility?
It is clear in the Jarvis decision that there is not a bright line. Okay, so our inspectors can be found to be investigators, and well, it wouldn't matter the other way, but yes. So I guess the question was, is there a bright? Yes, the answer is yes. There is indication in the Jarvis that even though an inspector is an inspector, if an inspector starts acting in a manner like an investigator, or like in the Jarvis case, acts as an agent for the investigator. If the investigator says, hey, you've got the powers, you go get them, that's not on. And the Supreme Court's made that clear, that it's not a label that's important, it's the facts of the case. So it's helpful, it's very helpful for us, but it's not a determinative factor, no.
All right, thank you very much. It's been a great talk. I think we should release you to your lunch. Thank you,
Okay.
Paul McCullough.
Great, thanks.